This is the WOKV Ask the Experts Weekend, discussing things that matter most to you. Local experts answering your questions. Call 855-765-1045. That's 855-765-1045. Now, the Consumer Law Hour with Eddie and Chuck Farah.
Good afternoon, Jacksonville. You are listening to the Consumer Law Hour on 104.5 WOKV. Our lines are open at 855-765-1045. We're waiting for your calls. My name is Scott Young. I'm your host here with Eddie Farah and Chuck Farah from the law firm of Farah Farah. They're your legal experts every week, giving you the insider information on what's new in the law and the ways that you can be protected by it. Eddie, how are you today? What's going on, guys?
Holding up, my man.
What's new? What's changing?
How you doing, Scott? Hi. Yep. Well, I can't hear you. Go ahead. I'm sorry. Hello.
What's new? What's changing in the law today, bud?
Okay. I can hear you now. We're in two different spots, so it's, we're trying to make things happen here. Yeah, I can hear you very well. Good. Hey, we got it going. We're here at a podcast studio on the south side, and it's really nice. But eventually we'll get the like you said, get the band back together again. But I think I want to kind of pick up where we left off last week a little bit, because I think it's very important people understand the type of coverage that's available under your auto policy called uninsured motorist coverage. And we got into it in some detail last week, but I wanted to just give you some fact scenarios that would cover you, and where you would not think it would cover you, but it does. For instance, if you have uninsured motorist coverage, let's say you're riding your bike down the street and you're a victim of a hit-and-run accident. Some guy hits you and keeps going. Even though you're not in your vehicle, your uninsured motorist is going to cover you for that accident. So whatever the at-fault driver should have paid you, if you have the proper coverage, you're going to receive that from your uninsured motorist coverage. And or let's say the guy who hit you while you're on your bicycle does stop and he's at fault, and he only has a $10,000 liability policy, but your claim is worth $50,000. And if you've got the right uninsured motorist coverage, your insurance company will pay you the difference. Let's say your case is worth 50, he pays you 10, you get 40 from your insurance company. So it's very valuable, and it even covers you when you're in other people's cars. You could be in your cousin's car and an accident happens. Your uninsured motorist coverage is going to cover you. It's very valuable coverage, and it's something you should really purchase. And when you look at the breakdown of the premium, when you buy an insurance policy, it'll give you how much you pay for PIP, what do you pay for collision, and so forth. Look at what you pay for uninsured motorist coverage. It's some of the most valuable coverage you can obtain, and it's not expensive. So you should really not even think twice about whether you want to have that or not, considering so many people are driving around without insurance coverage. But that's kind of where we left off last week, Scott. And if anybody has any questions about their uninsured motorist coverage or wants me to look at their policy, call our office. We have people there that can help you with that. Uninsured motorist coverage is also stackable. I mean, talk about adding coverages.
And it's not a lot to add that to your policy.
It's not. It's very inexpensive. Look at the breakdown. But when you have, let's say you have 3 cars in the household, you get to stack that coverage. So if you're in one vehicle and you're hit by an uninsured or an underinsured driver, you can stack all your for all your cars in your household. So if each car's got 100,000 on it, you got 300,000 of coverage available to that accident that you could receive, even though you're in just, of course, one vehicle. And they have to offer you stacking. For you to go to non-stacking, you've got to sign a document stating you do not want stacking. My recommendation would be to get as much stacking as you can, because you can stack as many cars in your household. And you can stack all cars from resident relatives. So if you've got like aunts or uncles or a father living with you and he's got an uninsured motorist, you can stack all that. So the insurance coverage goes on and on. Insurance companies don't like to sell it. They try to tell you, hey, I can save you some money. Reject uninsured motorist coverage. You don't need it because you've got Blue Cross Blue Shield or some sort of health insurance policy. But this provides a lot more coverage than that. And you should purchase it if you can. If you can afford it in any way, it's something you really got to have. So that's my take on coverage. The other thing is we talked about the impact rule yesterday, because to me that's just an interesting part of the law to me, and it comes around a lot. And what brought it to light was a call we had last week. As I stated, a gentleman and his wife were in their house. A car comes through the living room, and they're not hit by the car. No debris. There's no physical contact from the car that runs into the living room. But the wife has been distraught over it. She has emotional distress. She can't sleep, so forth. But, under Florida law, unless there's a physical impact, you're not able to make a claim for emotional distress. The dog that you've loved for the last 10 years, it's been with you. You see that dog get run over, and you're just emotionally distraught about it, no claim. Now, there are some exceptions to that, and I've seen cases where a parent has seen a kid hit by a vehicle or something like that, and, of course, that's a big emotional moment for them, and they've been able to make some claims for that. So there are some exceptions, but generally Florida has an impact rule which prevents anyone from claiming emotional distress when there's no physical impact. Now, if the emotional distress causes a physical injury, let's say you're so emotional upset about, watching your favorite dog get run over, and you have a heart attack as a result of that, then that's another way of making a claim, because you've had a physical manifestation of that emotional distress. So that's an interesting part of Florida law, the impact rule, and it's been on the books for quite some time. And people are in the courts now kind of find exceptions to that. There are certain circumstances where you can make these claims, but generally they're not allowed. So I don't know if I made sense of that, Scott, or if you understood it.
It makes sense, absolutely.
I appreciate it. Sometimes I get carried away and don't know. Start repeating myself because I know people think I'm just.
Well, it was an interesting concept, because you always hear people talking about the pain and suffering element, and pain is a physical manifestation. That's something that you can document, and it can have, it's kind of hard to prove sometimes, but it can substantially impact your ability to do things. It's difficult to demonstrate how an emotional thing may have an impact and have like a physical consequence like that.
That's why that's exactly why the law is the way it is because anybody can make a claim for emotional distress. I went into Publix and I saw somebody fall, and I got so upset I became emotionally distressed. I want to make a claim for that. I mean, you can imagine how many people would make claims for everything. Anytime they were emotionally upset, they would make a claim if they witnessed something. But that's why there's the necessity. The law requires a physical impact. That's exactly why the law is the way it is. It's a good point. If you remember we all remember the Pulse nightclub shooting, and as a result of that, of course, lawsuits arise out of things that happen like that, and there was a case filed by one of the victims of the Pulse nightclub shooting against the security company that the shooter worked for at the time this occurred, because he was employed. He was actively employed. He had a job, and he worked for a security company in Orlando. And he had been working at the security company for probably 8-9 years before this happened. And as the lawsuit developed, we learned that the security company knew that the shooter, because he had applied to become a corrections officer. He started the training for a corrections officer, and he was dismissed from that because he was talking about bringing guns to the classes, and he was talking about mass shootings. And so I guess the Department of Corrections says this is not a guy that's going to work in our system. So they get rid of he's dismissed from that job or that training to become a corrections officer. The security company that he ends up working for knows what happened with that. Secondly, the security company that he worked for submitted fraudulent psychological evaluations of the shooter, and they provided him with 8 hours of firearm training. Okay? In addition to that, they had noticed, the security company that he worked for had information or knowledge that he was unstable, had some psychological problems, and that he had expressed a desire to commit acts of mass murder. He's still working for the security company, and they know this. And they never had him undergo a psychological evaluation. They allowed him to work as an armed guard. Okay, so those are the facts as that were revealed in the course of this lawsuit. The court, ultimately dismissed the lawsuit because the court said that the shooter, they had all this knowledge, but what responsibility do I have to something he does on his own time, basically what happened. And so the court dismissed the lawsuit against the security company. The court stated that the shooter acted on his own free will outside of the security company's control. He wasn't on the job at the time. What he did had nothing to do with his job. He was on his own time. He had his own weapons, his own resources, and therefore the lawsuit should be dismissed. And the case was dismissed recently. Just recently, it was thrown out of court. So now there are circumstances. You start thinking of that. There are probably situations where, if the security company was somewhat involved, or he used maybe security company resources or information or something tied to the security company that allowed him to, perform this, the shooting, then maybe you could have brought him in. But under the facts of this case, there was no way that the court would allow anyone to sue the security company for what happened.
For example, if he had used company materials, if he had been, if he committed the crime with an issued weapon or while in uniform or during a scheduled shift, then they may have some kind of attachment to obligation on that.
Well, even the uniform, because I don't know if they get to take these uniforms home. I don't know if the uniform has a connection, unless they can. According to this, if you read the facts of this case, even though they had knowledge of this guy's instability, okay, they knew he was not all there. He still had firearms training. He still had a gun. I think you got to connect it a little tighter than that. Like maybe he used a gun. Took a gun from work that he wasn't supposed to have, and they didn't have proper security to protect him from getting through the gun. That way you could tie it in. But you've got to have a nexus or a connection between him and the security company, which they could not prove, in spite of all the information that the security company had.
I gotcha. Well, we've got our first caller of the day. We've got Frank from St. Augustine, and he's online with a question about Roundup and also a question about preserving an accident site. Frank, you're on the Consumer Law Hour.
Thank you. How's it going?
Thanks for calling in, Frank. Go ahead.
I wanted to comment on a condo not too far from your office on US 1 down here in St. Augustine, and I go out there and feed the fish, and sometimes I take my grandkids and just have a lot of fun looking at all the little fish fry that live in the grass there on the water's edge. And I found a large fish kill of all those a few weeks ago. And then just the other day, this past week, the pond maintenance fellow was out there, and I saw him spraying. And I said, "Hey, if you don't mind me asking, what are you spraying there?" And he said, it's glyphosate. I said, "Yeah, that must have been what killed all the fish, the baby fish, a few weeks ago." I was just amazed. He goes, "Yeah, I don't like to use it, but your condo board requested that I do this." And I was just amazed that that's still allowed, since these ponds connect to a canal, which connects to, how it is in Florida. It's going to eventually get into recreational waters.
That's a good point. You mean the Roundup, the glyphosate in the Roundup?
Yeah, these two ponds have an overflow into a canal, and with all the, recent cases that seemingly found it to be a carcinogenic substance. I'm surprised that it's just being wantonly used still.
Yeah, I agree. Here, you probably know what's going on with that, but the recent settlement with Roundup with Bayer. Bayer bought Roundup from Monsanto. Monsanto developed it. Bayer bought it. And they now own it, and they've just resolved these lawsuits, most of them anyway, for about $10 billion. And we had a number of these cases against Bayer, but in their agreement to settle, they have not, admitted any wrongdoing, because they're saying the FDA has said they don't see a connection between glyphosate and cancer. In Europe, it's a different story. If you look at what the people in Europe are saying, and Bayer's a European company, a lot of the people there are saying that, yes, there is a connection between Roundup and cancer, non-Hodgkin's lymphoma. But here in the U.S., there is no, although the courts and the juries have found a connection, and juries have looked at the science and said, yes, there is a connection, the government, the U.S. government, has not come out and said there's a connection with Roundup and cancer. That's why they're able to use it.
I had a second question, and I refer to these people who use them. I'm going to be kind of vague. We had a close friend that went to a somewhat famous eatery in the St. Augustine area, and there was what pretty much looked like a fire hose. Somebody was dewatering somewhere right in the parking lot. I think it was similar color to the sand parking lot. It was dusk, and she tripped over it and broke her jaw. Well, her husband was busy attending to her, but luckily they had another couple that was meeting him there that was actually able to take a picture, I think even with some of the blood from her broken jaw on the ground. And then the crew very quickly, within a few minutes after that action, put up, cones and spray painted the hose and everything. And I was just wondering if you had any, lucky for them, their friends were there and were able to get pictures in real time before those guys sort of covered up for their crime, for lack of a better term.
Yeah, no, that was a smart move to take that photograph. Did you know? Was there any surveillance in the parking lot? Sometimes these restaurants have surveillance, and we could preserve that also. That's something we do.
I went to your local office here the next day, and they were still trying to get her mended up, and I gave them your card. So you very well may be working on it at this point.
Yeah, I appreciate it. You've got time. In Florida, you have 4 years to file a lawsuit, but of course you don't want to wait that long, because the sooner you get involved, you can request the video to be preserved. You can write the restaurant a letter. It's called a preservation of evidence letter, and they're required under the law to hold on to that video. And if they lose the video or they do something to destroy the video, then the court can sanction them for doing that. And that way you have, the evidence you need. But she had witnesses with her, and they saw her fall, and they can testify as to the hose and so forth. But, of course, it would be nice to have the video, too.
Yeah, I don't know those specific questions because I haven't. But you were talking earlier about uninsured motorists, and, way back when I was just dating my wife, and we're married for 31 years now, she had an uninsured motorist. I think it was almost like on Christmas Eve that caused her to get into an accident, and she had a TMJ issue that was sort of took a long time to resolve, but we did get some compensation from that particular uninsured motorist of our own carrier.
Yeah, it always comes in handy. Again, you don't have to be in your car to use it, and a lot of people think that they're reluctant to sue their own insurance company. Say, oh man, I'm gonna lose my insurance, or I'm gonna cause my rates to go up because now I'm collecting for my company. Well, you know what? If you're gonna use that logic, why even have health insurance? Because you're paying a premium for your health insurance, and you mean you're gonna go to the hospital and say, don't bill Blue Cross because my rates are gonna go up? That's why you have it. I'm glad you used it. Some people believe it, Frank. Some people have uninsured motorists. Yeah. They don't want to use, oh, no, my rates are going to go up. Well, then why even have it? That's why you've got it. And so, go ahead.
Let me ask you this if you have another minute. I just had the stacking and all that, and see if this was the proper decision. And I got an umbrella policy, which would cover me, my wife, and my daughter of $1 million. And they said, that'll eliminate your need for uninsured motorists. What do you think of that?
No, what the uninsured motorist does, the uninsured motorist pays to you. Your umbrella pays to somebody else. God forbid, let's say you're going home and you cause a bad accident, and the injuries are worth hundreds of thousands of dollars or maybe $1 million. Your umbrella will protect you from having to pay out of your pocket. Your insurance company is going to pay that to the other person, not to you.
Okay, that's
uninsured motorist is paid to you. I'm sorry?
I'll have to go change that over on Monday then.
Yeah. The umbrella protects you against a lawsuit. Okay? That's let's say you have a $100,000 car insurance policy, but you're sued for $200. If you have State Farm, they'll pay the first $100, and then your umbrella policy will pay the other $100. So that way, you're off the hook.
So strictly a liability that wouldn't transfer over to.
No,
I couldn't do that pretty sure.
You're not getting any of that. No.
All righty, thanks. I'm glad I asked that question.
Well, thanks for calling in, Frank. Appreciate it.
All right, see you.
Yeah, man.
Frank, we appreciate the call. Thanks for listening. I see we got a couple of other callers on the line. We'll be with you guys right after a quick break as the Consumer Law Hour continues on 104.5 WOKV, Jacksonville's News and Talk. Jacksonville, we're back on the Consumer Law Hour. Lines are open at 855-765-1045. If you've got questions, our legal experts here to take your calls. Eddie Farah on the line and waiting for you. And we've got some callers on the line already waiting. We got Bill over in Hastings who wants to check in. Bill, you're on the Consumer Law Hour.
Hi. I just had a question in regards to the removal of Confederate monuments that's taking place in many cities.
Sure.
And I thought that here in Florida we had a law that protects Confederate monuments from removal, like a Monument Protection Act or something to that effect. And I was wondering if maybe they're violating that and whether we might be able to file a class action. People like Lenny Curry, mayor of Jacksonville, and and perhaps argue that the statues have to be replaced, even if they've been torn down by a mob, as the case may be.
Well, you have to. Have you looked at the statute? If there is such a statute, have you read it?
I haven't really studied it, but I heard there was a state law in effect.
Okay, because you're talking about a state law, or
right? A state law that protects Confederate monuments in Florida.
Okay, you should be able to find that on the internet, but there may be a municipal code. You want to look at that too, because Jacksonville has a municipal code, and then the state has its own set of laws. So you want to look at both.
But would the municipal code, under which they claim the authority to remove the statues, would that municipal code trump state law? If there's a state law protecting the monuments.
Yeah, you're right. So there's a state law that protects the monument, but there's a municipal code that says the mayor can do what he wants, sort of thing, right? Is that what you're saying?
Yeah, but if there's a conflict of laws, why would the municipal code take precedence over the state law?
You know what? In that situation, because probably that's a city asset. I'm just speculating now. I really don't know the correct answer. I can't guarantee the answer. But if the monument is a city asset on city property, I don't think the state has.
But not everyone in the city necessarily wants to see the statue torn down.
But maybe, I don't know if they've torn them down. Are they moving them somewhere else?
It depends on the situation. Usually they're very secretive about what they intend to do with the statue. I know down in St. Augustine, there's one at the Plaza de la Concepcion, and the Sons of Confederate Veterans has filed the lawsuit trying to make sure that they don't damage the statue during transit or something to that effect.
Yeah, I think the ones that have been removed are being preserved and held somewhere, and then they're trying to figure out where they're going to put them. That's my understanding.
Okay. Mm-hmm.
But yeah, I mean,
they seem to be treating the statues like they're personal property of the mayor of the city, and they're not. They're public property. So it seems to me as though, like, just for example, if the mayor decided he didn't like the Catholic Church and it's in his city, he doesn't have a right to go there with a bulldozer and start tearing it down just because he's the mayor.
I know, but that's on private property. That's church property. It's owned by the church. He has no. I mean, he's a trespasser if he goes does that. I mean, what they're removing is on city property. It's a city park. I mean, I grew up in we used to live in Springfield. One of those parks is over there. I mean that.
And the question at hand is whether or not the thing is being relocated as opposed to simply being removed. And unfortunately, nobody besides the mayor or anybody involved in the committee on that would have any insight into the grand plan on that.
No, yeah, they're still trying to figure out what to do with it. I think they've just got it probably in a warehouse.
There's no transparency. There should be transparency as to what their intent is, what they want to do with it, if they're allowed to remove it at all. I think they should have to have the public's approval. They shouldn't just be able to say, well, I decided I don't like it, so I'm having it removed, but I'm not telling you where, and maybe it's in the middle of a garbage dump somewhere or whatever they're going to do with it. And what about the ones that have just been torn down by mobs without any authority at all? Why shouldn't those be replaced or retrieved when they dump it in the river or whatever they're going to do with it? Why don't they send divers down, pull it back up, and fix it?
Well, has that happened in Jacksonville?
Well, it's happened in other places. I don't know exactly, because this is happening all over the country. So it seems to me that... that when they are torn down, they could be replaced.
And it may be on somebody's to-do list, and they just haven't gotten to it yet.
Well, the only thing on their to-do list right now seems to be tearing down every statue they can find, even statues of Christopher Columbus now that are under attack.
Well, there are a lot of people with a lot of lists, Bill.
Yeah. I mean,
it was Amerigo Vespucci that actually discovered the United States. That's what they call it.
He never really came here. Didn't he end up like near Cuba somewhere? I mean, he never made it to the U.S.
Christopher Columbus on one of his journeys landed on South America, but it was actually Amerigo Vespucci that first landed in North America.
I think the first trip he ended up in Hispaniola. He wasn't even here. I mean,
yep, that's right.
Because they had to go.
There was a German map maker that actually decided to name the continent America after Amerigo Vespucci.
Yeah. Well, I mean,
his name was Martin Waldseemüller. He was a German map maker who just started labeling maps America, and everyone just copied him.
Yeah, the statue thing's interesting. You're right. I mean, everybody. I mean, Lincoln, I don't know. I think, this is not really a political show, so, I'm a personal injury guy. If you want to ask me about an auto accident, I can tell you about it. I got some opinions about that.
So here's the thing. Supposing a protester tries to remove a statue or falls on them and it hurts their foot, who's responsible?
Okay, now you're talking. Scott, now that's something we can talk about. Yeah, the statue falls on somebody. Yeah, it's a good claim. Call me on that. All right.
Well, would your firm be interested in taking any type of class action lawsuit to prevent the mayor from tearing down any of these statues?
We're not. Again, we're a personal injury firm, and we do medical malpractice. We do some product liability, like we did Roundup, and we're a personal injury, and we're a tort firm, and we've never handled any cases like that. I'm not sure that it would be a class action.
Would this fall under the category of the emotional impact?
Yeah, because the impact will.
Right. Emotionally distressed by the tearing down of the statue.
That's why that's under the. You would not. I can tell you this. You would not have a claim under the Florida impact rule. So.
Mm-hmm.
Well, Bill, we appreciate the call. As always, a treat to hear from you. I look forward to your next call. We're going to move on. We've got, who else do we have on our call list here? We've got Robert over on the west side. Robert, you're on the Consumer Law Hour.
Hello.
Hey, Robert, how you doing?
Farah Miller can't complain. Don't do no good. Nobody wants to listen. Other than that, I'm doing fine.
Well, we're listening right now. What's going on, brother?
Yeah, we're listening for you.
I know. Listen, so they've got billions of dollars of lawsuits against Fair over Roundup. My question is, Monsanto developed Roundup, but during the Vietnam War, Monsanto developed Agent Orange. My question is the same ingredient in Agent Orange is what's in Roundup? Because the VA has determined that there's multiple different cancers and birth defects and stuff that Agent Orange is responsible for.
Well, when we've been involved in the Roundup stuff, and the Roundup, it's my understanding, if you look at the lawsuits that have been filed and the lawsuits that have been won against Bayer, it used to be Monsanto used to own it, it was for non-Hodgkin's lymphoma. They were able to prove to the jury a connection. So they weren't able to prove any other cancers, just that one. Are you saying Agent Orange caused different types of cancers than that?
I think the number is 13 different types of melanomas, birth defects, children born with a club foot. Because my sister, her firstborn child, was born with club foot and a stillbirth. And they tied that back to my brother-in-law being exposed to Agent Orange while he was in Vietnam. So if that chemical can cause a cancer in some people, what does it cause in other people?
Yeah, I think we may have lost the connection.
It's a deadly chemical. It's a pesticide designed to kill plants. But if it'll kill plants, it'll kill people.
What happened to the audio?
All right, I'll take your answer off the phone. I know you guys are locked up for time. There you go.
One piece off.
And you know who I am, right?
Who are you, Robert?
I'm Bob the Builder, Bob the Biker, Bob the Warrior.
Okay.
General contractor, 2 Harley Davidsons, and a Vietnam vet. I was in Vietnam for 10 or 68. It was no fun. I had a rear Escalon job, but they gave me a rifle. All right. Y'all have a good day. Okay. If you need to talk to me again, you got my phone number.
Thanks for the call, Bob. We appreciate hearing from you.
All right. Bye.
Thanks for calling in. But the issue is, that's a good point. And, I think about these things all the time because it's my understanding some lawsuits were filed. I don't think it was Monsanto. Wasn't it DuPont that made Agent Orange? Whoever it was. It doesn't make a difference. I thought some actions were held against DuPont, and some people were successful in making claims. But in terms of trying to make a claim now for Agent Orange, I think there's a statute of limitations problem that's way gone, which would prevent you from doing it. But I think we have to take a break.
Yeah, we got to take a quick break and come back for one more segment of the Consumer Law Hour. We got Randy on the line. Randy, I see your call out there, and we're going to come back to you when we come back after these quick messages. You're listening to the Consumer Law Hour on 104.5 WOKV, Jacksonville's News and Talk. Jacksonville, we're back for the final segment of the Consumer Law Hour. Lines are open at 855-765-1045. If you've got legal questions, our legal expert, Eddie Farah, available to take your calls right now. Randy in Mandarin is on the line. Randy's got a concern about a roofing accident and a severed tendon. Randy, you're on the Consumer Law Hour.
Hey, thank you for taking the call. I had an unfortunate roof fall that resulted in a severed Achilles tendon. I was taken to a level 2 trauma center because of the height of the fall. I don't know if I should name the facility or not, but
you don't need to.
When I got there, I'm sorry?
You don't need to. Go ahead.
Okay. When I got to the facility, there was an attending physician and a resident physician. The resident actually took care of the laceration, evaluated the tendon, and both the attending and the resident physician they concurred that there was no tendon involvement. So they sutured up the laceration, sent me home. About 6 weeks into my recuperation, I still wasn't regaining function of my tendon, my walk, and subsequently went to an orthopedic surgeon. He evaluated it, sent me for an emergency MRI, but it turned out that it was completely severed. He successfully repaired it. But I'm about a year into my accident, and I have regained function. Still have a little bit of a limp to my gait, But I'm just curious if do I have any recourse at all with that trauma level 2 trauma center?
That's a good question. And let me tell you, unless you can prove that as a result of what the trauma center did, you have a permanent injury, no. So, I mean, eventually, in your case, they found the problem, right, and they corrected it. Unless you can show that the delay caused permanent damage, you don't have a claim.
Okay.
So they ended up, maybe they made a mistake in not doing it. They did not conduct an MRI when you were in the emergency room?
They did not.
Did they do a CAT scan or anything like that?
They did X-rays only. I had also broken a rib, so they did X-rays of my rib, X-rays of my hip because they were concerned about my hip as well. But
X-rays don't show a broken bone, show a tendon issue or anything like that. Did they recommend on discharge instructions? Did they recommend you follow up with a specialist?
I don't recall. I know that when I was there, I asked if an orthopedist, we needed to have an orthopedic consultation, and they said no, that they were confident that the tendon had not been involved. Right. But I would have to look at my discharge papers to see what they said with respect to follow-up.
Yeah, there was probably something on the discharge instructions that said follow up with your primary care doctor or with an orthopedic. I don't think they would just.
Yeah, I'm pretty sure there was. Generically. Yep.
But the thing is, thank God, thankfully that you're gonna regain the movement you had before, as if they had performed the diagnosis properly at the beginning. That's the key. The delay, if the delay did not cause permanent damage, really not much you can do about that. I mean, our office would not handle that claim because it costs so much to handle these medical malpractice cases. It's so expensive, and that they're not. If it's just we handle them on a contingency, and you've got to put out so much money, you've got to have a permanent injury in order for it to make it a viable claim.
Do you think if I were to write a personal letter to that facility and just throw out maybe some pain and suffering numbers or something?
I got a better idea.
That work?
The letter's not going to do anything. You can write a letter; they'll just send you on your way. What you should do is you could file a complaint with the Agency for Health Care Administration in Tallahassee, and they're required to do an investigation and issue recommendations to the hospital. So that gets something done. It's called the Agency for Health Care Administration. I think you can do it online. You can file a complaint, and then they investigate the people who were involved in what happened. But writing a letter isn't going to do anything, I don't think. It's never done anything. Our clients have tried it. Nothing happens.
Sure.
Under Florida law, if you do plan to file a claim, or if you intend to, you have 2 years from the date it occurred for you to file your action.
Okay. The accident occurred, it'll be next month, August 3rd. So I'm almost a year into it. So I appreciate your input, and I probably will, at a minimum, contact that agency.
Oh, yeah, that gets stuff done. I mean, that's something they got to respond to, and they've got to investigate. So, but I mean, if you don't heal up the way you should, if your orthopedic says, and probably even your orthopedic doctor won't give you an opinion because they don't want to get involved in a lawsuit. But he should be upfront with you and say, hey, because of that delay, you're going to have limited movement, limited range of motion. Then maybe you have something there, depending on what you do for a living and how it affects your lifestyle. But if he says, hey, it's fixed, you're going to be okay, then, not much you can do.
Okay.
Right.
Very good. Thanks for your input.
Yeah, man.
Randy, we appreciate the call. Thank you very much. Looks like we've got just a moment left. We'll try and get one more call in. Diane in Baker County's got a question regarding squatters. Diane, you're on the Consumer Law Hour.
Thank you, sir. Actually, the property that I'm concerned about is in Savannah, Georgia, and I'm concerned about squatters' rights. The lady has lived on the property for about 14 years, not paying any lot rent because she was like part of the family. And now I have an opportunity to sell the property, and she doesn't want to leave. She actually has dementia a little bit, and she thinks I'm trying to kick her off of her property. What kind of defense do I have as concerning squatters' rights?
Well, we have an office in Savannah.
Okay.
I would rather consult. What you could do, Diane, is leave your phone number with Scott. Let me talk to my attorney in Savannah on Monday, and I can give you a call.
I appreciate that so much. Thank you so much, okay? You want me just to hold on?
Yeah, Scott will get it. We're not really, that's more of a real estate issue, but I think he has knowledge of real estate. Let me talk to him. He's in Savannah, and I'll be in contact with you on Monday about that.
All right. Thank you so much for your time, and I appreciate your program. It's very helpful.
All right, Diane, stay on the line for me. We're going to get you taken care of in just a minute. Eddie, that wraps us up for the week, man.
Okay. No time. Okay, well, I'll finish up next week. I want to get into the Agent Orange stuff, and we'll talk about that later.
All right. Always a pleasure spending an afternoon with you. Jacksonville, thanks so much for the calls today. Look forward to talking to you again next week on the Consumer Law Hour here on 104.5 WOKV, Jacksonville's News and Talk.